Well, we're here today with Hudson Valley, New York, DWI defense attorney Randall Inniss. Randy, how you doing?
I am doing well, Steve. How are you today?
I can't complain. It doesn't do any good anyhow, as I always say. The other one I like to use is when somebody says, "How you doing?" I say, "Better than I look."
I might have to use that one. I like that one.
Yeah, yeah. Well, hey, Randy, let's say I get arrested for a DWI. Are there some things I should keep in mind as far as my behavior goes and things I should do?
Sure. I like to say uh, to everyone, tell this to my family, if an arrest comes or works your way, first and foremost, be cooperative. And by cooperative, I mean uh, don't be cantankerous. I don't mean volunteer a bunch of questions. Actually, I mean just the opposite of that. You certainly have a right to remain silent. Even before you're arrested, when the police approach, they're going to ask you typically a series of questions, such as, do you know why I stopped you? And have you had anything to drink this evening? First and foremost, I can tell you that those questions are designed to elicit an incriminating response from you. So if you say, yeah, I know why I was speeding, wasn't I? Well, that is an admission. So even before you're arrested, this is the part where you've been stopped and detained. Um, you should limit, if anything, what you advise the police. It'd be best if you, at some point, very politely invoke your right to counsel. Now, some people may say, how do I do that? I don't like the way that sounds. It comes across as if I'm guilty. People try to explain things, but when they said, yes, I did have a drink, but it was 4 hours ago. Well, that's an admission that you were drinking, quite frankly. And the police officer will undoubtedly, in his report, reflect that he discerned the odor of an alcoholic beverage. So your statement, your utterance that you drank several hours before, supported his initial assertion that he detected the odor of an alcoholic beverage. And this is all part of their training.
Okay, are DUI, DWI checkpoints legal in New York State?
Yes, they are. They are, in fact, legal. Now, they have to follow a certain set guidelines of rules with every checkpoint. They have to have a set policy typically. They have to adhere to that policy. If they're stopping every vehicle or every third or fourth vehicle, they have to maintain that. A motorist who's approaching has to have a way to avert the a road check legally. I mean, they can, there has to be those measures in place. There has to be adequate signage or signs alerting of a road check. But yes, to answer your question very succinctly, they are legal in New York State. Yes.
Now, the first courtroom step is arraignment. And I believe the judge will say, how do you plead? Plead not guilty. Do you want me to assign an attorney or something like that? Can I represent myself in a DWI case? Is that a good idea, bad idea? Tell us.
Well, most courts are going to be reluctant to have you represent yourself. I'm not saying that's not legal, but they will significantly discourage it to the point that they will even appoint you an attorney if you're bound and determined to represent yourself. No, I don't think it is a good idea, particularly with a crime, which is DWI. A crime in New York State, by the way, is a misdemeanor or a felony, so it's not a good idea. And DWI is one of those special offenses where you serve two state government entities. One state government entity is the criminal justice system, that's the courts. but there is a second regulatory agency, state regulatory agency that comes into play here, and that's the State Department of Motor Vehicles. So the DWI, you're dealing with both of those state government agencies. Both of them can impose penalties on your licenses, on your driver's license, on your both can impose fines separately. Of course, the criminal justice system is the only one that can place you in jail, meaning the courts. DMV is a state regulatory agency in New York. But because you're facing two state government entities that are separate, I would not recommend you facing a DWI without an attorney. And it takes on more significance, more potential vulnerability or peril if you, for example, drive for a living, or if you hold a state professional license, such as a nurse or a physician or a lawyer or a social worker or real estate agent, teacher, corrections officer, a whole host of professions in New York State that, provide a professional state license, or in some cases, certificate.
What's the difference between a misdemeanor and a felony DWI?
Okay, so let's talk about the difference between a misdemeanor and a felony generally. In New York State, generally speaking, a misdemeanor and a felony are both crimes. So they're both criminal offenses. A misdemeanor is a crime for which up to 364 days in jail can be imposed. Now, misdemeanors are broken down into Class A misdemeanors, Class B misdemeanors, for which you can serve less time, or like a DWI is an unclassified misdemeanor. But generally speaking, a misdemeanor is a crime for up to 364 days in jail can be imposed. It used to be 1 year. They knocked 1 day off of it for immigration purposes. Now, a felony is more serious than a misdemeanor, and that is a crime also for which 1 year or more in jail or in prison, particularly, can be imposed. And there are fines that go along with misdemeanors and felonies, depending on the class. I mean, felonies are class A, B, C, D, and E, typically. In Class A felonies, typically a homicide, there's a Class A1 and a Class A2 felony, and then there's B, C, D, and E.
Will a DWI conviction affect my employment opportunities?
Well, yeah, it can. Any criminal conviction can impact employment. That's a very broad question because it depends on employment, the type of employment that you seek. And in some cases, you can, obviously, depending on the position, you can be employed with a misdemeanor, in some cases, a felony. There's no blanket prohibition. It depends on the employer. Certain government positions may be a lot more restrictive on who they hire, et cetera. But certainly a criminal conviction, which is a misdemeanor or felony charge, can impact your employment. It has the possibility to, particularly if you're in a sensitive, or what they consider a sensitive area of employment, such as, I don't know, maybe a daycare center or a teacher or a nurse, or certain employment that involves a particular population of individuals who may be vulnerable. It's certainly not limited to that, but certain classes of employment are more stringent. And of course, it depends on the particular misdemeanor or felony for what you're convicted of, whether it's a DWI or whether it's some sort of an assault or a violent felony. It makes a difference as well.
Very open-ended question here for you, but I get a DWI, I've been arrested. Should I go for a plea bargain, or should I go to court? What determines that?
Well, you're going to go to court irrespective whether it's a plea bargain or beyond that, hearings in a trial. But if your question is rooted on whether or not you should go to trial, that is so certainly dependent on the individual circumstances of your case. Was there an accident? Was there not an accident? Do you have priors, prior DWIs or driving while offenses? Do you have prior other offenses that relate to alcohol or drugs? Was someone injured? Was someone not injured? I can tell you that the vast majority, simply over 90% of these cases are resolved and come to disposition or resolution without a trial. And sometimes that helps both parties, quite frankly, in terms of the case that the people or the government has to present, or in the case of the defense that the defense attorney does on behalf of his motorist client. Again, oftentimes, as I said, these things are almost 100% fact specific. Oftentimes, these cases come to a defense attorney with admissions from the client, with circumstances that may circumstantially lend itself a certain way. But there are aspects that you can certainly defend, a DWI very robustly. And it starts with the reason for the stop to begin with. It starts with the defense attorney's knowledge of the standardized field sobriety test. I can tell you, as a former 22-year state trooper, I have quite the knowledge of the standardized field sobriety test, and I am in fact an instructor in that regard. So when the police officer undertakes the standardized field sobriety test, and those are the roadside tests that the police ask you to take to help cultivate and develop their probable cause, there can be defenses that come to the fore from that perspective as well. If you have a skilled defense attorney who is versed in DWI or DUI defense. So, there is no right and wrong answer. It is absolutely so dependent on the facts and circumstances of each individual case.
So this is going to be dependent on the facts as well, but is it possible to win a DWI case?
Absolutely. It's very possible. I mean, there's so many factors, as I said, that come into play. The instrument, the machine, as it were, the breathalyzer, the different models, Draeger and others, but they're certainly not infallible. The law enforcement agency is responsible to calibrate them on a certain basis. Ever so often, sometimes that isn't done. Sometimes the police officer involved does not follow the rules or the checklist that is required. You see certain things at times, like the motorist potentially coughing, or in some cases burping, or they may have some sort of a medical background that can lend itself toward a particular defense. So yes, it is very, very possible to defend and in fact win a DWI case. In some instances, you might have to call in an expert to testify about the breathalyzer, because the police are not experts in the breathalyzer. They're just operators. In New York State, they get a permit. They have to pass a test similar to one I passed many, many, many years ago to be a certified breathalyzer operator. But yes, they are cases and where you can win a DWI a charge at trial, or even before trial.
So how long will a DWI conviction, let's say it's a plea bargain, but I get a conviction for whatever reason, how long will it stay on my record?
Well, that's interesting. In New York State, there has been legislation that was passed in 2023. It's called the Clean Slate Act, and it isn't effective until November of 2024. I don't know when this will be placed, this video. That allows for certain misdemeanors and certain felonies to be sealed at a certain time, assuming there is no intervening arrest. So with a DWI misdemeanor, which qualifies for the Clean Slate Act, or even a DWAI traffic infraction, those crimes, assuming it's resolved and, those crimes for a misdemeanor can be removed from your record within in 3 years. So a misdemeanor will be removed typically from your record within 3 years, assuming, of course, you do not get arrested within that 3-year period. So, and also, just to get a little bit more granular about this, if your misdemeanor is disposed of on a certain date, but you have 3 years of probation assigned to your misdemeanor, then your record won't be cleared until after those additional 3 years of probation are served, because you're still under the care and supervision of the criminal justice system, as it were.
Are drug DWIs, are those tougher for the cops and prosecutors to prove?
Well, if you're arrested there's a crime called driving while ability impaired by drugs. And that's typically occurs where the police suspect you have, that your operation is impaired by something other than alcohol. It could be an illicit drug, coke, heroin, could be marijuana. It could be a prescribed prescription medication. That's very important to know, that you can be arrested and charged for driving while ability impaired drugs for medicine that has been legally prescribed by a physician. But whether or not that's more difficult to prove by the prosecution, that's a really open-ended question. And again, it's facts specific. With the DWI, with alcohol, there's a per se level of 0.08 blood alcohol concentration with a DWI. There is no per se limit with any sort of drug level. I mean, there's certain drugs that are in your system at a more elevated rate than others, but there is no baseline number consistent with the particular drugs that are alleged. Now, to prove to demonstrate certain charges of this nature are done just by admissions by the motorist. And that's why you should never make any admissions to the police officer. Never be rude, but don't make any admissions. At other times, there's a blood test that has to be taken. Typically, the police officer will provide the vial to the medical professional, whether that's a nurse or an EMT or whomever, or phlebotomist, whomever is whomever is drawing the blood. There is a special vial that the police use, and that's different from the medical vial that the medical professional has. And it should be in the police vial because that has a coagulant and anti-clotting component within the law enforcement vial, as well as another substance that preserves it, and the second keeps it from clotting. So there are, for forensic purposes, meaning court-related purposes, they have a different vial for the police. The police provide typically. So if you have a case, there may be certain defenses where they derive your the substance that's in your in your body based merely on the medical vials versus the forensic or police vials. So I mean, but there's a whole bunch of points that can be made and measured, defenses. There's a lot more reports that are generated when there's a blood sample taken. The police will typically, if they do a preliminary breath test for you at the scene, and that comes up 0. That's the portable one. They'll take you to the hospital to draw blood. And sometimes if you're taken there by ambulance, or when you get to the hospital, when they do their preliminary reports, meaning the medical personnel, those reports may differ from the police account, so that might present, the medical personnel are not looking for signs or indicia of drug use in the same manner that the police are. So those cases can be challenging for the people, and sometimes more accurate, because you can get a medical professional that says they've done this hundreds of times, and that makes it, that much more in their minds of a solid case. So it's I guess it depends on your perspective, and each case rests on its own facts and circumstances, of course.
So what does it mean if I get an aggravated DWI?
Well, in New York State, just to touch the basics, it means that you blew, your blood alcohol concentration is a 0.18% or more. So that's a little over double the legal limit of 0.08. You're a 0.18 or more. That's one way to get an aggravated DWI. That's a misdemeanor, typically, if it's your first arrest, or even if it's your second arrest, if it fell outside of 10 years, it'll still be a misdemeanor. Another way that you can get an aggravated DWI, and this one is a felony that I'm about to describe, is where you are intoxicated, you're 0.08 or more, and you have a child, quote unquote, the person in the vehicle at the time of your driving and intoxication, and that person, that child, is less than 16 years of age, so the age 15 or under. That is also an aggravated DWI in New York State, and those particular circumstances are charged as a felony.
You mentioned to me a couple of times that you defend a number of cases where someone has a professional license, doctor, teacher, nurse. Talk about that, will you?
Yeah, so certain professions, doctor, teacher, nurse, as you said, are issued licenses by the government, by the state. Indeed, the Department of State, in many instances, issues a license. And if there is a criminal charge levied against that person, and by the way, those individuals who have such professions, they're typically fingerprinted by the government, as a function of obtaining their professional license. So if you're a teacher, your fingerprints are on file. If you're a lawyer, if you're a real estate agent, security guard, member of corrections, a police officer, etc., your fingerprints are taken and are on file as a function of your employment, as a consequence of your employment, of getting that professional position. And so when you get arrested for driving while intoxicated charge in New York State, when the police fingerprint you at that point, pursuant to your arrest, bells go off, as it were. There's an alert to the government, and oftentimes you'll find that, if it's on a weekend before you go to court, before you go back to work on that Monday, your agency knows about it. The school may know about it, because your prints are on file and they're in a special place, and they ring, ding, 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 almost like, this person got arrested, and he is a doctor, he is a physician, a pharmacist, whatever. And so, yes, your employer will get notified. Now, depending on the profession, whether you're a nurse or a doctor, some of them have an obligation to report at the time of renewal versus, and I'm talking about, when I say report, I mean report to the government, not to your employer. Your employer, whether or not you have, and this is very important, whether or not you have a responsibility to report to your employer depends on your employment contract. You could have reflected at this, so that's a question that can't be answered with specificity. It's your employer, and in your individual employment contract may require you report an arrest proactively or right after it occurs. But the government sometimes, and it depends on what profession you're in, may require it when you renew versus when it happens. And some people have a year to renew, or 6 months before they renew, or, depending on how far before the arrest they renewed their license. So, from our perspective, and I've arrested a host of people as a police officer, as a state trooper who were professionals. But if your counsel, if your attorney is skilled and they are able to get that charge reduced to below a criminal offense, below a misdemeanor, or below a misdemeanor or a felony, down to the area of a traffic infraction or other violation, or dismissed outright, typically that should not impact your professional license. Typically, again, all of the circumstances are depending or are individualistic, but typically that is in fact the case. Now, as I said, to be distinguished from the fact that you may or may not have to report that to your employer is consistent and dependent on the employment contract, or in some cases the union contract, that accompanies your employment with that particular agency or private company or entity.
My youngest daughter is a high school English teacher, and she's not a big drinker, but occasionally she likes to go out with some friends and have a couple of beers, just go out with the girls night out. And well, she always takes an Uber. She said, I am not going to chance this, I just,
very wise.
Yeah. And she
That's
said
very
the other benefit is the place they like to go is always, there's never any parking anyhow. So makes a lot of sense to.
Yeah, I mean, Steve, there are so many more options that are available today than 15, 20 years ago. And it's so much more prevalent. I mean, obviously Uber, Lyft. Before it used to be just cab companies. When I worked for a professional sports league, the NBA, we put something in place so that a limo service could pick up a professional athlete. But in those days, that was during the infancy of Uber and Lyft and these rideshare organizations, and players were very reluctant to take anything that the league, as it were, set up, where, they'd have a sense of where you were, even though it was confidential. But the point is, it's better to spend money on an Uber and Lyft. I don't care if it's $300, because attorneys are very expensive. I'm certainly not an inexpensive attorney. I don't think, anyway. Maybe I am to some. I think I'm fair, but either way, it's a lot more than $300 or $500, and it really isn't worth the risk. Or fundamentally, just designate a driver, but don't take the chance, because typically at night there are so few vehicles on the road, depending on what city you're in, and cops are more attuned at night on a weekend to be looking for a DWI, since even in their training given by NHTSA, which is the Federal National Highway Traffic Safety Administration, which promulgates all the training for police officers throughout the United States in impaired motorist detection. They provide that information. Statistics show there's an increased probability of an impaired motorist on the weekend at night, and they give that statistical number. So the police who are out there are looking for, or presuming, if you will, if you're out there at a certain hour, that you may be prepared. So in some cases, for all I know, it could be some inherent bias based on the stats and the data in which they were trained.
We've been speaking with Hudson Valley, New York, DWI defense attorney, Randall Inniss. Randy, thanks very much. Appreciate it.
Thank you for having me.